Mr. Perl.
Yes, thank you, Chairman Pierce, members of the board. I appear here today once again on behalf of the Tennessee Chamber of Commerce and Industry, which, as I said previously, represents both large employers and small business owners throughout the state. I begin, Mr. Chairman, with your statement quoted in the notice of proposed rulemaking that the purpose of this rulemaking process is to improve the process for all parties in all cases, and I would submit that the proposal here falls far short of that. Here, the board majority's proposed election rule overhaul dramatically curtails the time allowed between the filing of a union petition and the actual election, just as it did in 2011. And in doing so, it conflicts with the statutory policy in favor of free debate guaranteed under the First Amendment in Section 8C of the Act. The Second Circuit so aptly stated that in Healthcare Association of New York State against Pataki, 471 Fed 3rd 87 in 2006. They said Section 8C not only protects constitutional free speech rights, but it also serves a vital function within labor law by allowing employers to present an alternative view and information that a union would not present, thus aiding the workers by allowing them to make informed decisions. As far back as 1962, this board in Sewell Manufacturing Company explained that it seeks to remove all obstacles which prevent or impede reasoned and informed choice by employees. Here the board does just the opposite. It doesn't just remove obstacles, it imposes them by steamrolling elections in the name of streamlining the process. The period of time between the filing of the petition and the holding of the election is critical. It's in this critical period that management has the opportunity to communicate its position on unionization to employees, many of whom would have already signed union authorization cards that secured the election. A quick, accelerated election can leave an information void, heightening the risk that employees may vote without having the benefit of the employer's alternative viewpoints. Moreover, after employees receive information from their employers, they need sufficient time to develop understanding, ask questions if necessary, and consider each alternative before they are asked to vote. The drastic rule changes proposed here minimize, rather than maximize, the likelihood that all voters will be exposed to the arguments against as well as for union representation. The board's reformulation instead reduces the election process, as stated by members Miscamara and Johnson, to vote now, understand later. In seeking to balance the apparent diametrically opposed views of the board majority and employers, we should look to the election results of recent times to see whether unions are being disadvantaged under the current framework for representation elections. NLRB elections demonstrate that unions win more than 60% of all RC elections. This percentage is strong evidence that the present system works fairly for all parties. As a prior speaker said, the proof is in the pudding. That the board dismisses this evidence as irrelevant, as it did when it issued its final rule in 2011, tends to create the perception that the board is committed to creating as short an election cycle as administratively possible, even at the expense of shortchanging procedural safeguards and statutory protections. Assuming arguendo that the board adopts its quickie election model in violation of its own self-professed standards to improve the process for all parties in all cases, we propose that the board at least adopt a notice requirement requiring unions to formally notify any and all employers at the outset of any organizing activity directed against them. The board is acting under the assumption that employers generally become aware of union organizational activity prior to the filing of a petition. This generalization is not true in very many cases, and the board is therefore underestimating the detrimental impact of a quickie election process on both employers and employees. Indeed, the board acknowledged when it published its final rules in December 2011 that at least in some cases employers may in fact be unaware of an organizing campaign. A notice requirement would institutionalize the process and be consistent with the chairman's declaration that the rule changes are intended to improve the process not just for some parties, but all parties in all cases. And at a minimum, the notice requirement is an essential safeguard for fundamental fairness and more clearly achieves the statutory policy of guaranteeing employers free speech and employees free choice. In conclusion, resolving representation questions fairly trumps resolving elections more speedily.
So if an employer has a policy, and I understand many employers do, a policy in their handbooks that say we believe in a union-free work environment, would, by your proposal, there be an obligation on the part of the employer to notify the unions that that's what their policy is?
No, I don't believe there's a representation process engaged at that point, Mr. Chairman. Some employers have such a statement in the handbook. I would suspect that the vast majority of small business owners, which are included in the Tennessee Chamber's membership, do not have such policies, and many of them don't even have handbooks.
But if such a policy does exist, wouldn't you consider that to be campaigning?
No, not necessarily. I think that's a statement of the company's position.
Right.
That's not a part of a representation campaign.
A statement, well, I guess we can get into semantics about that, but you would not think that that's campaigning even if it was contained in an employee handbook?
Correct.
Okay.
Yeah, Mr. Perl, thanks for being with us today, in addition to your comments yesterday. Do you have any problem with the efforts, and I don't want to speak with the other board members, but I think that there's support across the board, no pun intended, for trying to address the issues associated with those cases where elections are delayed beyond 56 days or more than 2 months, in some cases much longer than that. Do you have any problem with our focus in part on trying to identify and eliminate to the extent that we reasonably can the causes for delays in those cases?
No, I don't. In fact, I think the board contributes to the delays in many cases. For example, and you're dealing with it in the NPRM, the board's present policy is on a request for review. The board will not schedule an election within the next 25 days to give the board ample time to consider and rule on the request for review. That 25-day period could be shortened if the board steps up and deals with it in a much more timely fashion. That's one of the kind of incremental improvements that could take place outside of this notice of proposed rulemaking process. So I think the board can do some things internally to help itself. But when you look at the questions and the responses before about, well, how many days should there be between petition and election? Should there be a minimum? Should there be a maximum? I think, in a sense, we need to look at what needs to take place to ensure a fair and free election here. And in yesterday's panels, we looked at a number of the key components, including the pre-election hearing, to deal with vital issues like supervisory status. You cannot shortchange the election process by having a bright line 20% rule that no issues can be heard during the representation process hearing, the pre-election hearing, unless they constitute more than 20% of the unit, even vital supervisory issues. If you eliminate that, yes, you can get to the election much quicker, but then you have a much more extended, prolonged election representation process, because now you're going to deal with issues such as the case I mentioned yesterday, the ITT lighting case that went over 4 years. Because the vital issue of supervisory status was not dealt with by the regional director of the board pre-election.
Thank you.
Okay.
Just really quick. I just want to get some more information about sort of your pre-notice model to the extent that you thought it through. How much pre-notice would there be before the petition, and then what would the deadline be before the election in the case that there was pre-notice?
Well, Member Johnson, the notice requirement proposal that I submit respectfully to this board is the quid pro quo if you proceed with your quickie election approach here. There has to be some opportunity, some ample opportunity for the employees to hear from both sides. And I would submit that that notice requirement should be triggered before the union seeks to have any solicitation of
Right,
union
I
authorization.
understand that. I was just trying to get your concept of how long that's going to be.
And if the union gets the card signed, it's going to depend on the size of the unit. But I think there has to be a notice requirement as the quid pro quo for the quickie election model. And that should be triggered before any authorization cards get signed. To give the employer, to put the employer on notice.
Right, but
That this organizing campaign is going to commence. Now, even the notice requirement is not a perfect solution, because for small business owners, which comprise a majority of the employers in this country here, they still have to go out and get ample representation through the form of attorneys or some advisors, and that's going to take some time.
right, but
So-
I'm sorry, because we're running out of time. I don't want to be rude or anything like that, but let's just assume it takes the union like 3-4 months to get the cards together, because, they have an ample amount of time to assemble cards. Is your proposal basically before the very first card is signed, say, and 4 months out before the petition comes in, the union would give the employer notice if we had a more accelerated election process on the back end?
That is correct.
Okay.
Thank you, Mr. Perl.